Hi folks, and welcome back to Conveyancing. This is the video series for contract settlement, and we're looking at part 2, settlement related issues. So this is video 4, and in video 3 we had a look at paper settlement and e-conveyance, and now we are going to look at possession and merger. So without further ado, let's have a look at possession. Now, as you can see, clause 5.5 there says that on the settlement date, in exchange for the balance purchase price, the seller must give the buyer vacant possession of the land and improvements except for the tenancies. And where and what are the tenancies, you might ask yourself? Well, they will be set out in the reference schedule in the early part of the contract, and you can see I've got the blank part of the reference schedule there for you. Now you can see in italics the note that goes along with that in the reference schedule. If the property is sold with vacant possession from settlement, insert nil, otherwise complete details from your residential tenancy agreement that the seller would necessarily have with their tenant. So there is an implied condition in all of that, that if that reference schedule section is left blank, then vacant possession is going to be given at settlement. And obviously possession will be when the buyer gets the handover of the keys and access cards and so forth. That's going to be delivery up of possession. Now, there are some issues around vacant possession and what it is, when the obligation to give vacant possession will be breached. In the Ibrand Estates case, UK case, it was held that vacant possession is more than mere absence of people. The purchaser has to be able to assume and enjoy immediate and exclusive possession, occupation and control of the property that they have bought. It should be empty of chattels. However, this is only going to be breached if the chattels left substantially prevent or interfere with the enjoyment of the right of possession of a substantial part of the property. Now, that's going to be a question of fact in each case, and you can see my rather poor attempt there to render a basement that has been filled up with rubbish. That occurred in the Cumberland consolidated case. The cellar was so full of rubbish that effectively couldn't be used. So there they did establish a breach of a right, the right to vacant possession, and you can have the court order removal of the offending items. However, this is generally going to be more of an exception rather than a rule, and a buyer accepting a possession, as I say down there, would generally waive their right to claim damages. You couldn't really insist on reduction of the price to cover, for example, cleaning expenses and that kind of thing. So to breach the obligation to provide vacant possession, it's got to be something fairly severe to get you across the line and convince a court to do something about it. The text gives you a few good examples of cases that have fallen down one side or the other of the line, so I'll let you explore those in a little bit more detail, but I did like that picture of the basement with the rubbish in there, rather good mental picture of what the breach of that kind of clause is going to look like. So what about lawful use of the property? Well, we touched on lawful use in the video series on seller disclosure. The present use of the property is going to have to be set out in the reference schedule along with the local government there. That will need to be specified also. There's no compensation payable if the use is not lawful, because the seller doesn't warrant that the use is lawful under clause 7.4 sub 5. I've given you a little screenshot of it there. However, we did note that under the provision dealing with property adversely affected, even though the seller hasn't warranted that the present use is lawful and so no compensations payable, nevertheless you can terminate under, well, the buyer can terminate under clause 7.7 of the REIQ standard terms in the Houses and Land and I've given you a little screenshot of that there. So if the contract date, present use is not lawful and that hasn't been disclosed, the buyer can terminate. Now, that was a good recap, but how does that all tie into vacant possession and nature of possession? Well, it's also going to be a failure to provide possession, and there will be a breach of clause 5.5. So if a certificate of classification is required, for example under a town planning scheme, for the buyer to lawfully occupy the property and that is not provided, then the seller has not provided lawful possession. That should be possession, and the buyer can terminate. So that is how lawful use ties into possession. Lastly, we need to cover off the issue of chattels and property and when title passes in terms of possession. So we know that under clause 5.5 of the standard terms, we need to have the seller giving the buyer vacant possession. What exactly do they have to give vacant possession of? Well, you can see I've reproduced 5.5 down there again for you. The land and the improvements. So the land is set out in the reference schedule, and we had a little look at that when we were in the previous video series when we were talking about identification of the property. And improvements, what are they? Well, in clause 1.1 sub 2 sub V, improvements are the fixed structures on the land, including all items fixed to them, stoves, hot water system, fixed carpets, curtains, blah, 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 but does not include the reserved items. And reserved items means the excluded fixtures and all chattels on the land other than the included chattels. So to sum it up, all fixed structures on the land are going to be caught as improvements, and possession is going to have to be given to those unless they have been specifically excluded in the reference schedule. And you can see up there I've got a snippet from the reference schedule there. So all fixed structures are improvements. They're going to have to be given possession unless they've been specifically excluded. However, chattels are a different story. As you can see in the definition of reserved items, all chattels on the land are going to be reserved items unless they've been specifically included. So all of the loose items on the property, the seller is going to retain those unless they have been specified in the contract as included chattels. And where they are included as chattels, then possession is going to have to be given for those as well. Note that title to the included chattels passes at settlement. What happens if the seller unfortunately leaves their chattels on the premises after settlement? Well, this is a bit of a problem. If you look at 5.6, the seller's got an obligation to remove all of its reserved items, that is the excluded fixtures and everything else, all of the other chattels on the land other than the specifically included chattels, before settlement. You've got to repair any damage if you damage the property in removing the items. But look at 5.6 sub 3. Any reserved items not removed before settlement will be considered abandoned, and the buyer may, without limiting its rights, complete this contract and appropriate those reserved items or dispose of them in any way. So note to the wise, always advise your sellers to get everything, loose items, chattels that have not been specifically included, get everything off of the property before the time of settlement, because otherwise once that buyer takes possession upon settlement, then you've lost those items. I do have a colleague who was acting for a rather happy purchaser. There was a very large Winnebago left on the property that had been bought and sold, and unfortunately for the seller, they thought that they could just pop back at any old time and collect it. My colleague's buying client, had very cannily removed the Winnebago from the premises and sold it off. And they were able to do so because under 5.6 sub 3, the property, the chattel left upon the property had been deemed abandoned, and therefore the buyer could sell. The buyer can, as it says, appropriate and dispose of them in any way. Wow. So, where a buyer has actually negotiated for the inclusion of chattels in the contract itself, always, again, note to the wise, the buyer's lawyer really needs to search the personal property security register to make sure that there are no securities over the chattels that have been purportedly included in the contract. That would be a very unhappy find, to work out that there was security over the included chattels. That would be an encumbrance, and it's not something that you want to find out later on down the track. So that is the issue of chattels and the passing of title and chattels. Okay, so lastly we need to have a look at merger. Now we know that in every conveyancing transaction there are a number of different steps involved, and there will be different legal consequences attached to those steps. We know about execution of the contract and the rights and obligations that flow from that. We know that the seller has to execute the transfer, otherwise the settlement can never happen. But steps 3 and 4 are very significant steps. We've been talking about settlement throughout this video. And once you get to this stage, then the doctrine of merger will come into play, and there will be some very serious rights for the buyer that fall away after settlement. So step 3, you'll have a look at that top orange block there, settlement being the exchange of transfer and the purchase price. After that time, the buyer will be deemed to have accepted title. So we first had a little look at the buyer's acceptance of title when we were talking about the property adversely affected clause in the REIQ contract, when we were doing the video series on seller disclosure. If you don't object prior to settlement in relation to those kinds of things, then you will accept title subject to any problems that emerge. So after settlement, your buyer's right to object, we say that this is merged in the conveyance, and that's where you get the doctrine of merger. The conveyance can really only be set aside for a fairly narrow range of circumstances. They have to be more than a mere defect in title or misdescription in the property. You need to have some kind of fraud, a total failure of consideration, misrepresentation, mistake, all of those vitiating factors that we had a look at in contract law. That's where those factors come into play if the buyer wants to get out of the contract after the settlement date. If the transaction has then progressed forward from settlement to actual registration, so step 4, it's going to become even harder for the buyer to set aside the transaction. Why is that? Obviously because once they're registered on title, their title will be indefeasible, and it really is only if the buyer can squeeze in the matter into one of the exceptions to indefeasibility that they will be able to back out of that transaction. So you're going to have some kind of fraud, unconscionable conduct, equitable misconduct, that kind of thing, in order to get out of your conveyance at that point in time, very late point in time. So certainly by that point in time, except in very, very, very minuscule range of cases, your rights as buyer will have merged, and that you will have taken title subject to whatever you haven't objected to at that point. The doctrine of merger will therefore affect some of the obligations in the contract. However, other collateral obligations in the contract may actually survive merger. So if you have a look at 10.6 of the REIQ Houses and Land Standard Terms, it says, despite settlement and registration, any term of this contract that can take effect after settlement or registration does remain in force. So any conditions to which registration doesn't give effect will actually continue on. Warranties, collateral or other rights to the purchase money, rights to compensation given by the contract where you actually claimed that pre-settlement will all survive merger. As I say there, if you're going to make a claim to compensation under 7.5, you need to give that written notice pre-settlement. Other than compensation claims under 7.5, your other collateral obligations will survive up to the maximum limit of the limitation of actions, which is 6 years. However, if there has been naughtiness in the wings, fraud, misrepresentation and that kind of thing, there will not be any time limit for expiry of that particular obligation. So the doctrine of merger, it's a very serious consequence for the buyer. However, it doesn't mean that all clauses in the contract will expire or terminate or go down with the sunset once settlement has occurred. Collateral obligations, particularly to the purchase price, will survive. So there are cases that are described in your text whereby the purchase price was agreed. Unfortunately, the adjustments, there were errors made in the adjustments on the settlement statement, and the purchaser ended up paying quite a bit less than the purchase price. They settled, everything went by, in fact 5 years went by, and then the seller realised that almost $40,000 had been lopped off the purchase price because of this error. They were able to successfully claim the balance of the purchase price from the purchaser even at that late stage. So certainly things like that, those kinds of collateral obligations, they will continue to survive post-settlement. I'll leave you to read the rest of the text in that area for yourselves, but that really is the issue of the doctrine of merger, and that is the video series, Contract Settlement Part 2. And if you have any queries or questions, as I always say, send me a message on Teams, via email, give me a call. Other than that, I look forward to chatting with you in a Zoom sometime soon. And from me, it's bye for now, guys.